Hello, everyone. This is Sarah Zakaria, Associate Director of Alumni Relations at the University of San Diego. I'm excited to have you join us today for our Mid-Career Alumni Network webinar, Estate Planning 101, with our four-time alumnus, Kevin Gordon. The Mid-Career Alumni Network is an official affinity group of the USD Alumni Association, dedicated to providing relevant programming and services to alumni who graduated within 11 to 30 years ago. First, I would like to thank you for taking the time out of your busy schedule to join us this afternoon. Before we begin, please be mindful that today's webinar is being recorded. Access to the replay of this webinar will be found on the USD Alumni website and the University of San Diego YouTube channel about 1 month from today. So if you need to step away from the webinar and are interested in viewing it at a later time, the archived broadcast will be posted. On your screen is a control panel with a chat area where you are able to ask questions. Questions are very welcomed, and Kevin is looking forward to hearing what you have to say. So please submit questions and we will answer as many as time allows. If you experience technical difficulties, please submit concerns via the chat area. In the event that we all experience technical difficulties, please submit concerns via the chat area. We will attempt to resolve the issue as soon as possible. If we are unable to do so, we will reschedule the session and an email with the new date and time will be sent to you. Without further ado, I'd like to introduce today's presenter. Kevin is a four-time USD alumnus. He received his bachelor's, MBA, Juris Doctorate, and LLM from USD. His law practice is devoted to estate planning and transactional matters. He is a member of the San Diego County Bar Association, the State Bar of California, and the American Bar Association. He also served as a vice president and a member of the board of directors for the San Diego Imperial Council Boy Scouts of America. He is the chair of the Scripps Health Foundation Gift Planning Advisory Board and serves on the University of San Diego Plan Giving Professional Partner Council. Welcome, Kevin. We now turn the time over to you.
Thanks, Sarah. Can everybody hear me all right? I'll let Sarah answer that question since I don't know if I can hear the rest of you.
Yes, we can hear you just fine.
All right, very good. Thanks, Sarah. As Sarah mentioned, I'm an attorney, and I want to remind everybody I'm an attorney here in California. So for those of you who might be joining this conference from another state, I want you to keep in mind that I'm licensed in California and not in your state. I'll say that generally most estate planning concepts, sort of transfer state by state, wills and trusts and intestate succession, all operate pretty much the same state by state, but there are some state exceptions. So, this is a disclaimer saying that, if you've got a specific state question, you should talk with a lawyer in your state. Today, we're going to talk a little bit about estate planning basics. This is just a very basic overview of the estate planning process. And I'm going to walk you through why people do some estate planning and what the basic documents are. And at the end, I'm going to go through some estate planning mistakes, which really highlight the importance of getting your estate plan together in a formal fashion. In other words, having a written estate plan. So I want to jump right on in, and I want to tell you about the reasons that people often come in to see me to establish a written estate plan. And usually there are two driving factors. The two main factors are the birth of a child or the death of a family or friend. And that usually will drive a young couple to me, or an individual who's lost a family member or friend. The third most common reason somebody might come in to see me is that they're doing their annual tax return with their accountant or meeting with a financial advisor, and that other professional advisor asks, where is the estate plan? And that usually will drive people into my office to start talking about these types of things. There are some really good reasons to get a written estate plan together. And one of those reasons, very close to my home, I was orphaned as a young child. I was 2 years old, and my parents were both killed in an auto accident. And they were young, and they didn't have an estate plan. And so the first reason I have here on the first slide, I'll move to the next slide here, is nominating guardians for minor children. Now, because my parents were young and they didn't have any, any assets to speak of, they, of course, didn't have a will. And in the will is where you would nominate guardians for your minor children. So in my case, my brother and I ended up being raised by my father's parents, and my sister was raised by my mother's sister and her husband. And so my guess is that my parents probably, if they had a voice in the matter, probably would not have wanted children to be split up. But of course, we don't know because they didn't have a document, and things worked out the way they worked out. There was a court hearing, a guardianship hearing, and both families came in and things worked out. I'll have to say that kids are resilient, and I wouldn't change a thing. We all turned out to be responsible citizens, and life goes on without the document. But if you have minor children, I suggest that you want to get something down in writing in your will about who you'd want to care for your kids if you're not able to. All right. The next reason, good reason, to execute estate planning documents is to control the disposition of your property. And what that means is you want to say who gets what and when they get it. Now, if you don't have a written document, each state has a probate code. And in that probate code, there is the law of intestacy. And so when you die without a will, the probate code will direct who gets your things and when they get them. If you have minor children, they generally will receive your assets when they attain 18. A lot of people think that that's too young for young people to get any substantial amount of money, and would prefer to have them receive assets at a later date, maybe after college or at even a later date. So by creating your own estate plan, which generally would mean a will and trust, there are other documents we'll discuss, but you would get to control who gets what and when they get it. And you might also have other conditions on the receipt of money. For instance, if you had a child with substance abuse problems, you might include provisions that say that the child should test free from controlled substances in order to have access to the funds, things like that. All right, third reason is to minimize taxes and expenses. So I mentioned if you die without a will, your estate will pass via the laws of intestacy. That requires a probate proceeding, as does, by the way, dying with a written will. Both of those require a probate proceeding, and that can be a lengthy and drawn-out process, and it's a public process. So, in modern estate planning, particularly in California, the revocable living trust has become a tool by which you can avoid a lengthy probate and conservatorships if you become incapacitated. And that can minimize some of the expense involved in administering your estate. If your estate's in the taxable range, and we'll talk a little bit about how much that is in a later slide, doing a written estate plan can also help you minimize those taxes. There are some techniques that you can use to minimize your estate for estate tax purposes, but still get the property where you want it to go. Okay, and finally, you want to have a written estate plan so you can facilitate the transition of assets belonging to you to assets belonging to your beneficiaries. And what I mean by that generally is that you get to select the people that will be the executor of your estate or the successor trustee of your trust, the person who's going to manage that transition. And this is not a small matter. If you don't select somebody, the court will select somebody for you, and it may be a person that you wouldn't select yourself. So to the extent that you want some control over, over your own affairs and the people that will be involved, you would, in your written estate planning documents, identify those people. Other important actors in your estate planning documents will be agents under a healthcare power of attorney or advanced healthcare directive. These are people that would make healthcare decisions for you if you're not able to. And attorneys, in fact, under a durable power of attorney for asset management. And we'll talk a little bit about what that document does as well on a later slide. But these are people that you select to manage your affairs. And if you don't take an affirmative act by putting a plan together, then the court will select those people for you. All right. I'm going to move to the next slide. And what I want to do is talk about the different ways that property can pass from you to other people at death. And most people think of a will as sort of the basic estate planning document, and that is a very basic estate planning document. And in that document, you can direct who gets what. But there are many, many, many people who don't have even that basic document. And so I mentioned the process of intestate succession. The probate code says who gets what and when they get it. So that is sort of a baseline estate plan for everybody, except you didn't draft it, the state legislature did in your state. And I'll give you an example in California about what that intestacy statute says. All right, and this is just a small part of that statute. There's a lot more to it, but let's say if you live in California and you're married, California is a community property state. That means that one half of the property, one half of all earnings earned during marriage are owned one half by each spouse, and that's called community property. Separate property would be anything that you come into the marriage with and keep separate, or property that you might receive by gift or inheritance. So if you die without a will and you're married, the intestacy statute in California would say that your surviving spouse will receive all of the community property. And if you have no children, your separate property would also go to your surviving spouse. If you have children, if you have one child, the law of intestacy in California would say your spouse gets all of the community property and one half of the separate property, and your child receives the other half of the separate property. And if you have two children, the spouse would get 1/3 of your separate property, and your children would divide the other 2/3. So that may or may not be the distribution scheme you would select had you put your own written estate plan together. All right. Let's move on to the next item here, which is the manner of holding title to property. So we all own bank accounts. Some of us have real property, our homes that we live in. And oftentimes we don't think, particularly with real property, about the way we hold title to the property. So oftentimes we'll buy real property, and the real estate agent will, ask you the question when the documents come in, how would you like to hold title? And they will often recommend a joint tenancy with the right of survivorship to a married couple. And that's a fine way to hold title. What joint tenancy property is property that's jointly owned and property that will pass to the surviving joint tenant upon the death of the other joint tenant. And so real property can be held that way, your vehicles can be held that way, bank accounts can be held that way, and property that's held in that manner will pass to the surviving joint tenant without a probate. It's a non-probate transfer. But what many people don't realize is that it also bypasses your will and trust. So let's say you hold property as a joint tenant with a spouse or other family member, or maybe even an unrelated person. And your will says, give everything to my children in equal shares. Well, everything but that joint tenancy property will pass in equal shares, but the joint tenancy property will go to the surviving joint tenant. So oftentimes, holding things in joint tenancy can defeat an otherwise well planned out written estate plan if you don't, while you're doing that written estate plan, also examine how the title to property is held. I can't tell you how many times, and we can talk a little bit about this when we talk about it in the later part of this presentation. We talk about estate planning mistakes, but a very common occurrence when I'm administering or helping an executor or successor trustee administer an estate after a person has passed away. We'll find that a person, usually a parent, will have a bank account, and they will have added a child as a joint tenant for convenience. In other words, the child may be helping them pay bills, maybe making deposits and basically helping a parent out. And the parent, kind of unbeknownst to them, they think they're doing the right thing by adding the child to the account, and their intent is to leave all of their assets in equal shares to their children, but we find that the bank account goes to the surviving joint tenant, that child, and is not included in the division for the children. Now, even if the child, who's the joint owner on that account, wants to do the right thing and share that bank account with his or her siblings, there can be gift tax consequences to that, because the IRS views that account as belonging to the surviving joint tenant, and instead of that property passing from the deceased account holder, if the child wants to share that account with his siblings, his or her siblings, it will be treated as a gift from the surviving joint tenant who's the sibling. So it can cause some problems. But on the other hand, it can also be a very inexpensive way to do some estate planning. So, for instance, if you didn't have a written will and couldn't get one together, but you wanted an account to go to a particular individual, you could hold that account as a joint tenant, which, by the way, can have gift tax consequences. So you need to be careful about adding somebody to the account without thinking about it in advance. Another way to have an account pass outside of probate and outside of your will is to name what's called a pay-on-death beneficiary of that account. So oftentimes with bank and brokerage accounts, you can arrange the title to that account in your name, and then after your name, the letters POD or the words pay-on-death, and then you name a pay-on-death beneficiary. Those accounts will pass outside of probate, and basically all the other person needs to do is present a death certificate to the financial institution, and they'll release the account to that person. All right, the third bullet on this slide talks about beneficiary designations. And for those of you that have retirement accounts, which would be IRAs, 401ks, 403bs, 457 plans, these are all retirement accounts. Those accounts pass via beneficiary designation, and you need to make sure that you have valid beneficiary designation forms on file with the custodian of those accounts. The problems I see with beneficiary designations tend to occur after there's been a divorce, where somebody will forget to change their beneficiary designation form to their children, from their now divorced spouse, or to another place where they want that account to go. And so often there's a statute. I'm not a family lawyer, but I understand that there's a family law here in California that removes divorced spouses from as beneficiaries. But the problem with that, in other words, automatically without you having to take an affirmative step, the problem with that is that if you don't then put in a new beneficiary designation form, frequently the retirement plan documents will have your estate be the default beneficiary. And if you don't have a valid beneficiary designation form on file, that default beneficiary can trigger a probate where you could otherwise avoid a probate by having the valid beneficiary designation. So beneficiary designations are another non-probate transfer. If you've got a valid designation, then you can typically avoid probate. Same goes with life insurance. Those pass outside of your will and outside of your trust. That's another thing to consider as well. I mentioned that oftentimes we'll have problems with joint tenancy accounts passing to the surviving joint tenant when the account holder or the account originator thought it was going to be divided in equal shares for children. The same thing can occur with beneficiary designations. You just have to be aware that those pass outside of your will and outside of your trust. So if your goal is to avoid an unequal transfer, in other words, you want all your children or beneficiaries to share equally, you want to make sure that you coordinate your beneficiary designations with your overall estate plan. All right.
I had a question come up, if that's okay. For your 403B and other retirement accounts, can you designate the beneficiary as your trust?
Yes, that's a really good question. And I want to warn everybody that the retirement plan rules are pretty complex, and they also change from time to time. So you want to be very careful about selecting, and you want to get advice when you are selecting your beneficiary designations. Generally, naming a trust is not tax efficient in terms of naming a beneficiary of a retirement plan. And the reason is that if you name a trust a non-individual beneficiary, the beneficiary, the trustee of the trust, is required to withdraw all of the plan proceeds within 5 years of the date of death, which means that all of the income that's associated with those withdrawals will be recognized within 5 years. On the other hand, had you named your surviving spouse, the surviving spouse could do what's called a spousal rollover of that plan and treat the plan as his or her own, and then they take withdrawals according to their own required beginning date and according to their own schedule, which typically is longer than 5 years. So that allows for deferral of recognition of the income tax that's associated with retirement accounts. Second, if you name a non-spouse individual beneficiary like children, they can typically treat the account as what's called an inherited IRA. And in that case, they would be able to take withdrawals, substantially equal withdrawals over their life expectancy rather than in the compressed 5-year time frame. So it allows for continued deferral of income tax and generally is more tax efficient. So to the extent you can name individuals, it's generally preferable, but there are some situations where you might name the trust. For instance, if you had very young children and you felt that 18 was too young for the child to receive your many hundreds of thousands in your retirement account, you might name the trust, and then the trustee would withdraw the money from your account, pay the income tax, which it needs to be paid in any event, but the money would then be trapped inside the trust and then be distributed according to the terms of the trust. So the trust might say, until my child attains age 25 or a college degree, the trustee should make distributions like a parent. They shouldn't just allow the child to take a lump sum distribution and go to Cancun for spring break. So there are reasons. Another reason might be if you had a special needs child who had, was receiving government benefits and giving them a retirement account, might disqualify them from government benefits. or if they have a substance abuse problem and you prefer that they not be able to take a lump sum withdrawal. So there are legitimate non-tax reasons to name your trust, but you just need to be aware of the tax consequences. And I find that most people with young children prefer to name the trust. But once the kids attain a more mature age and a more mature level of responsibility, that they take the trust off and put the kids on direct. So that is, I hope I answered that question, maybe more than you wanted to know.
Thank you. That was perfect.
All right. Number 4, wills. This is the common estate planning document that everybody thinks of. This is my last will and testament, and it's a fine document, and it works. And you can even do a handwritten will. It's called a holographic will. But there are certain requirements. So, for instance, in California, if you're going to do a holographic will, it must be entirely in your handwriting. So it must be signed and dated, and every portion of it must be in your handwriting. If you have any typed portion, or you typed it out and then signed it, it ends up not being a holographic will, and you have other execution formalities, such as you need to have 2 witnesses. You all need to be in the room at the same time. So there are rules about how wills need to be signed, and if they're not followed, then it can put the will in jeopardy in terms of it being a valid document. Some people say, well, can I have a trust in my will? And the answer is yes. If you wanted, let's say you had young children and you had a basic will, but you didn't want your kids to get everything at age 18, you could have a trust inside your will, and that would be called a testamentary trust, which would call for a later distribution of assets to children and name successor trustees and that type of thing. The problem with creating a testamentary trust is that the will need to be probated, and so you end up with the probate proceeding, which you can completely avoid by item number 5, which is a living trust. And a living trust just means that you create it while you're alive. It doesn't spring from your death. So number 5 is what's called a living trust, sometimes called the full technical name is an inter vivos revocable trust, or revocable living trust. And that document is helpful for a lot of reasons. It's basically a substitute for your will. It's the document that says who gets what and when they get it, who's going to manage your affairs if you're not able to. But the benefit of having a living trust is that if you become incapacitated, you have a stroke or something, and you're no longer able to manage your own affairs, what you would do without a living trust is your family would go and have a conservatorship proceeding down at the probate court, and they would appoint a conservator of your estate and maybe a conservator of your person, and that person then would have authority to manage your financial affairs and where you would live and those types of things. That conservatorship proceeding can be avoided, particularly conservatorships of the estate, which means financial matters, if you have a living trust, because the successor trustee can't just commence acting as soon as you stop acting as your own trustee. So there are benefits during lifetime in terms of avoiding conservatorship proceedings. And then at death, a living trust, if the trust is properly funded, meaning that your accounts and assets are titled in the name of the trust, you can avoid a probate proceeding. And there's still work to do. There's administrative things to do at your death, but you don't have to go to court and have it supervised by the court. So it minimizes some cost and basically streamlines the process. So let's move to the next slide here. I want to talk a little bit about other. Oh, actually, let me go back one. I mentioned that the living trust is a substitute for your will. But I want to make sure everybody understands that you still need a will. And typically, when you have a living trust, the attorney that assists you will also create a will that we commonly refer to as a pour-over will. And the pour-over will says, if there's anything not in my trust when I die, put it into the trust and have it pass according to the trust. So all of your assets pour into the trust and then get administered as part of the trust. It's important to have that pour-over will because sometimes you'll have an asset that is not in the trust. For instance, a very common thing that occurs is if you have a parcel of real property, your home, and you dutifully put it in the name of the trust when you did your estate plan, but later you go to refinance your property, sometimes lenders will require you to remove the property from the trust when you do your refi, and then they fail to put it back in the trust and don't remind you. So sometimes people end up with their house that's outside of the trust. And if that occurs, we want to make sure that the will capture, put it into the trust. Of all your assets outside of the trust is more than $150,000. This is the California rule again. Then you're required to have a probate to get it into the trust. All right, on the next slide, and I want to talk about some other documents that are part of a basic estate plan. And the first one that we have here is called a durable power of attorney for healthcare. This document is the document where you name agents to make healthcare decisions for you if you're able to. It's a really important document, and it's actually the one that I find people have the most difficulty with, because you're kind of confronting questions about what type of care do I want if I'm forced with being put on a respirator, if I'm in a persistent vegetative state, do I want my agents to remove artificial feeding and hydration, things like that. So I think it's a really important document, and I think the real good thing about it is that one, you're naming the people that you want to make those decisions, and two, you're giving those people some direction about what kind of care you want. It's very difficult for people who are at the foot of the bed in the emergency room or the intensive care unit when they are faced with questions about brain death and removing people from machines if they don't know your wishes. So it's a great document to sort of at least put your baseline wishes in there. And then I always suggest that you communicate with your agents, even more so outside of the document, just so they understand what it is that you'd like in certain circumstances. You talk about paralysis, stroke, and these types of things. There are other names for a power of attorney for healthcare. Sometimes you'll hear the term advance healthcare directive. A durable power of attorney for healthcare is an advance healthcare directive, but the power of attorney names agents. And advance healthcare directive gives your direction, but it doesn't necessarily name agents. So I prefer to use the durable power of attorney for healthcare because we've got people that can make decisions. All right, number 2, durable power of attorney for asset management. This document allows an agent, called an attorney in fact, the power to conduct financial affairs for the principal. Now, in a general, basic estate plan where there's a revocable living trust involved, the plan generally is to get all of your assets in the trust so you can avoid a probate at death. But there will be some assets that pass outside of the trust, and we mentioned those retirement plans which pass via beneficiary designation. So retirement plans are not owned by the trust. They're outside of the trust. And because they're outside of the trust, your successor trustee does not have authority to manage those accounts. So what we like to do is have a durable power of attorney for asset management, which grants a person the power to deal with those accounts. And almost always, people will name the same person as they've selected for their successor trustee, because the successor trustee is the person that's handling all their other financial affairs. So it's important to have that document. It's a very powerful document in that your attorney, in fact, can basically contract on your behalf and can sell your property and bind you to contracts. And it's a very powerful document. The person steps in your shoes and can conduct financial affairs just as you could. And so there are two ways these things can come about. One is called a springing durable power of attorney, which will spring from your incapacity. In other words, if you have your capacity and you're not ill or otherwise unable to manage your affairs, the document has no effect. But as soon as you become incapacitated, the document will spring into action, and they call that a springing durable power of attorney for asset management. Another way is just to make it effective immediately. And that way, if you travel a lot or something and you want somebody back home who can conduct financial transactions for you, you might make that document effective immediately. I want you to notice in both items 1 and 2 the word durable. So durable power of attorney for healthcare and durable power of attorney for asset management. The word durable in that context means that the powers granted under those documents survive your incapacity. You could write powers of attorney all day long, and as you become incapacitated, if it's not a durable power of attorney, that document becomes ineffective. It no longer works. So in a estate planning context, we want these things to be valid when you have capacity, because that's when you need assistance managing your affairs. So we always want the powers of attorney for both healthcare and asset management to be durable powers of attorney, meaning that they survive your incapacity. And like I mentioned, in many cases, sometimes these documents only become effective upon your incapacity. So it's important that that there's language in the document about the document being effective after you lose capacity. Okay, third item on this list is called a property agreement. In California, I mentioned a community property state, meaning that anything that's earned by either spouse during marriage, provided there's not a premarital agreement that changes things, or a postmarital agreement that changes things. So we're a community property state owned one half each by each spouse. And there also can be separate property, which is property that you come into the marriage with and keep separate, or property that you might receive by gift or inheritance. Now, one of the benefits of being in a community property state at death is that all of the community property, in other words, both halves, will get a new basis for income tax purposes at the first death. So what that means is that if you bought a share of stock for $1, a share of IBM stock for $1, and now it's worth $100, if you sold that during your lifetime, you'd have a $99 gain and a tax to pay on that $99 gain. At death, if that property is community property, no matter which spouse dies, that $99 gain will disappear. It will be as if you had purchased the share of stock for $100, and then the survivor could go out and sell the stock for $100 and have no taxable gain. So for community property, it's a real benefit, because both halves get a step up in basis at the first death. Separate property, on the other hand, will only get a step up if the owner dies. So if it's owned by husband and wife dies, husband does not get a new basis of separate property. Husband has to die in order for that separate property to get a new basis. So what the property agreement does, and it basically identifies the character of your property as either community, all community, or part community and part separate, or it may be all separate. But the point of the agreement is to identify the character of the property. This becomes particularly important for joint tenancy assets. So, for instance, you may have a bank account held in joint tenancy, but there's not a presumption. You really can't tell if it was community property or if both parties contributed part of their separate property to that account. So if you have an agreement that says that that joint tenancy account is community property, then you have some documentary evidence to show the IRS that both halves deserve a step-up in basis. Okay, number 4, general grant and assignment. This document is what we call a general trust funding document. I mentioned before, provided all of your assets are in your trust at the time of your death, you can avoid a probate. The general grant and assignment is a document that the trustors, that's the people who would create a trust, would sign, and it basically says, we hereby give everything we own except retirement accounts to the trust. And we agree to go to our bank and our brokerage houses and transfer all of those accounts into the name of the trustees of the trust. This document signifies your intent to get all those assets into the trust, and if for some reason you didn't make it, you signed this document and you didn't make it to the bank to transfer the account into your name, in California, we would take general grant and assignment document down to court, and we would ask the judge to please not make us have a probate. And generally, if the assets listed in that general grant and assignment, they would allow us to avoid a probate and treat the asset as if it has actually been transferred to the trust. Okay, any questions from anybody so far? Sarah, did you see any questions in the chat circle there?
We don't have any questions right now.
Okay, great. Well, what I'm going to do is briefly touch on estate tax, and then we'll go into some common mistakes for estate planning. And then we'll open it up for questions. And if you have questions as we go, feel free to type them in there, and we'll get them answered. All right, so in the last 5 years, we've had a lot of change in our estate tax rules. California does not have an estate level estate tax, so it's the one tax we don't have in California. We've got plenty of other taxes, but in California we do not have a state level estate tax. But some states do have a state level estate tax, and you need to be aware of that in your planning. The figures on this estate tax slide are referring to the exemption, that's the amount you can pass not subject to estate tax, for federal tax law purposes. So for instance, in 2015, an individual may pass $5,430,000 free from estate tax downstream, so down to kids and younger generations. That's quite a bit of money, and so a married couple can get almost $11 million down free from estate tax. If your family or relatives have a large estate, an estate that exceeds that exemption, they're looking at a 40% tax on amounts in excess of that exemption. So it's not a small tax, it's almost half of amounts in excess of 5.43 million. And so if you're dealing with an estate, sizable estate, you absolutely want to get in and talk with an estate planning attorney who can help minimize or mitigate the tax to the extent possible. There are a number of techniques, more advanced estate planning techniques that can be used to help minimize the estate tax. One of the new rules, we used to have to create a family trust, revocable living trust, and then split the trust into two parts at the first death of a couple in order to capture both spouses' exemption. There's a new rule that's been around for a couple of years now that now permits a surviving spouse to claim a deceased spouse's unused exemption. And they do that by filing a timely filed estate tax return which means within 9 months of the date of death. And by claiming, affirmatively claiming that unused exemption. So estate planning for estate tax purposes has gotten simpler in that regard. It's also created some more complexity in terms of making the decision about whether or not you want to use a traditional approach by splitting the trust, or whether you want the deceased spouse to claim the deceased spouse's exemption and just keep one trust. So that's a little beyond the scope of this talk today, but it's important. And if you're dealing with estate tax, if you're dealing with an estate that is in the estate tax range, you're crazy if you're not talking to a lawyer about how you might minimize those taxes. Okay, going to go to the next slide, and these are just some common estate planning mistakes that I have identified. There are plenty others that are not appearing on this list, but these are sort of basic problems, and they highlight that I think the need to have a written estate plan, and once you have a written estate plan, to keep it updated. So common estate planning mistake number one is not having a written estate plan. Who's going to make your healthcare decisions? Who's going to pay your bills and control your assets? Do you really want to have a probate or a conservatorship if you become incapacitated? And disposition of your you get to say.
Kevin, are you there?
What happens to your stuff and what happens to your body. So if you for instance, the healthcare power of attorney, you get the direction on what type of care you're going to receive. All right, the unfunded trust. Let's say you've gone out and created a revocable living trust, and you have a pour-over will and powers of attorney for healthcare and asset management. Gone out and done that, but you have failed to transfer your assets to the trust. You're going to end up with a probate. And the one I see that's most painful is if you have a timeshare. So we'll have people who have a revocable living trust. Maybe they have a timeshare property in Florida and in Hawaii, and they didn't put their timeshare in the name of the trust. Well, they end up with a probate in Florida and Hawaii, and sometimes in the state where they reside. That can be a real surprise for the survivors. So it's really important to get your assets in the name of the trust in order to avoid those types of surprises. All right, we talked about also assets passing outside of the trust. So if you've got joint tenancy assets with other people, you just have to remember those are not passing under the trust. All right, treating children differently, unless there's a good reason. So I have a great story about a couple that came in. They had 3 children. 2 of the children were successful physicians, and the other child was in and out of college, still trying to figure it out, didn't really have a great job, and they were worried about this third child. So I hadn't met the children at all, but I kind of had seen the scenario before, and so the parents say to me, Kevin, we're concerned about our third child. We would like to leave half of the estate to that third child because we're worried that he or she may not get a good job and will need extra help. And the other 2 are successful physicians, and we're not worried about them. And so it's my job as the estate planning lawyer to do what the client wants, but I always, in situations like that, sort of challenge the client. I say, now, I just want to make sure I understand. I don't know your children, but I predict that these 2 children that were physicians, that you never had any problem with them as children. They always came home and did their homework when they were supposed to. They always came back, at curfew time or before. They got through college in 4 years or less, and they got through graduate school in the allotted time, and they're now thriving, successful professionals. And the child that you're worried about, that you want to give more to, was the child that always drew negative family attention, never did their homework when they were supposed to, and I went on with the story. In any event, at the end of the talk, both parents were weeping. They literally were crying. I said, "Kevin, how did you know? How did you know that this was the deal?" And I said, "Well, I've seen it before." And so I asked them, I said, "Please consider what message you might be sending those children that did everything you ever asked them to do. What message are you sending them by giving a larger share to the child that was more of a problem and hasn't yet figured it out?" And they changed their mind and decided that they had that a third each was plenty for each of them, and that they loved their children equally and didn't want to send that message that this other child somehow loved more. Anyway, you get the idea. No matter what you think the kids might think, let me tell you that the kids are very aware, the survivors are very aware of unequal treatment. And that doesn't just mean unequal value, it might also mean unequal distribution control. And what I mean is by making an outright gift to a child versus holding a child's share in trust. So if I had two children and I said, "You get your equal shares outright, free of trust, and you may spend that money as you wish, but this third child, we're going to hold that child's equal share in trust because that person doesn't manage their assets well, or for whatever reason, that child's going to feel that they were treated differently, and it can cause resentment. There are perfectly good reasons to do that, to treat a child differently. For instance, if there's some special needs or substance abuse or serious financial mismanagement, there are absolutely reasons to treat kids differently. But to the extent you can avoid it, it makes for a much smoother transition and helps the kids have a better relationship going forward. All right. Adding children and others to bank accounts. We talked about this already. Those accounts will typically pass to that person outside of your will or trust and can upset your otherwise well thought out distribution scheme. All right, and a couple of others here. Appointing unqualified successor trustees. A lot of people say, "I want my eldest child to be my successor trustee," and which is a totally fine thing to do. But I always remind people that that is a job. It's not an honor to name somebody successor trustee. It's a job. The person has tax returns to file, and investments to manage, and distributions to make. And so if the person is not well organized and getting their own tax returns in on time, then they may not be the right choice for you in terms of successor trustee. You always want to get somebody that is organized and smart enough to get advice if they don't know the answer to something. And your options basically are a professional trustee, which would be a bank or trust company, a licensed individual, which would be it's a professional trustee that's an individual. Oftentimes it would be a CPA or other financial professional that has gone and become licensed by the state. And then the third option would be just a non-professional individual, which is the eldest child or responsible child, or whatever. Some individual, could be a friend. But you want to pick somebody who is responsible and organized, because it really is a job. And I always like to say that you should give that person the power to appoint a professional in case they feel like they're not up to it. And that way they're not saddled with the job. They can get somebody else in that is a paid professional and get the job done. Okay, appointing one child as a trustee over another child's ongoing trust. these are obvious reasons of you really don't want one child in charge of the other child's purse strings. That's a recipe for discord. Failing to plan for management transition in family businesses. I see this pretty regularly if you've got a family business and there's one child involved in the business and another child not involved in the business, but the estate value is all tied up in the business. So what happens when this working child, the child that's not involved in the business, now becomes an equal shareholder with the working child? It can cause some problems in terms of management and control of the company. You really need to be thoughtful about how the company might be managed after your death. Okay, not having clear instructions regarding personal property, and we're getting pretty close to the end here, so I'm happy to take questions as we wrap this up. The most common arguments are not about financial assets. They're not about real estate. They are about their grandfather's pocket watch, or the piece of art, or even a piece of clothing in some cases. So it's really important to have clear directions about personal property.
Kevin, I do have a question. If I can interrupt you, how do I get started finding legal counsel to specifically help with estate planning? What do you suggest?
Yeah, that's a good question, and I think that if you have other financial professionals in your life, like a CPA, tax preparer, a financial advisor, that those people will frequently know quality estate planning attorneys in your neighborhood, or in your part of town. And so those are good people to ask. Asking friends, and when I say friends, I mean asking successful friends who appear to have some financial knowledge, and they have their act together. Ask them who their advisor might be. And then, of course, you can always call the local bar association and ask for a referral. There's frequently a lawyer referral services with the local bar association. But what I suggest is that you select an attorney that has particular expertise in estate planning, and that you not select a lawyer who sort of dabbles in estate planning and also does business work and some other things. You want that person to really know estate planning, because there's a lot of pitfalls, and particularly if you have assets that will be subject to estate tax, there's a lot of mistakes that can be made. Yeah, like a very common mistake that people just don't think of is making a substantial gift to grandchildren. Is such a natural thing to do, but there's another tax out there called the generation skipping tax, and if you're not careful, you can walk into that and end up paying a much larger tax. That is not such a concern now that the exemption is so high, above $5 million, but in the past has been a thing that happens sometimes. You end up tripping over the generation skipping tax, and you didn't even realize that you did it. So it's important to get somebody who practices in the area. Hope I answered that question. All right. Not formally documenting loans to children and other family members. Believe me, kids keep track of the financial support parents are giving to other children. So their sibling, they know if their siblings always coming to mom and dad for money. They know if there's a loan out there. And if you're making a gift, that's one thing. Let it be known that it's a gift to a child. But if it's a loan where you expect to be paid back, you have to document it. If you don't document it and you die, then of course the child that took the loan is going to call it a gift, and the kids that didn't get the loan are going to call it a loan, and then you're going to have this discord, which is what I think most parents want to avoid. They don't want their kids arguing after they're gone. Same thing with advancements to family members. That means that here I'm giving you an advance on your inheritance, or this gift is meant to count against your share of the inheritance. You got to document those things.
Kevin, I I had another question come up, and I know we're just about at 1 o'clock, so I'm going to interject and ask, what are the typical range of fees for estate planning documents? What should a person expect to pay for a will and trust and
Okay. Yeah,
durable
I think
power of?
I'll speak about kind of the local market in San Diego here. I'm in Carlsbad. A basic estate plan, which would include if I'm talking for a married couple, which would include a revocable living trust, powers of attorney for health care and asset management, pour-over wills, and a property agreement, and maybe a deed putting your house into the trust. Um, I'll say generally runs between $2,000 and $3,000, and that's sort of a middle market cost. Some lawyers charge more, and some lawyers charge less. Most lawyers, including me, charge by the hour, and so so that usually is like 7 to 10 hours of my time. But there are things that can cause the cost to go up, and those things are complicated assets, children from prior marriages that you want to treat differently, complicated distribution schemes, family businesses, if you have entities and things like that, lots of real property that require, multiple deeds. So there's things that can drive cost up, and generally it's time. So the more organized you can be going in, kind of knowing what it is that you want, that helps keep the time down. And the more complicated your life, you just have to expect that it's going to cost more money. But that's sort of a range. May not be the range that you run into when you speak with a lawyer, but you just have to understand that circumstances vary between people. So it's very hard to sort of give a range without knowing specific circumstances. All right. I think I've covered pretty much all. There's 2 bullets left. Not telling family members about plans for charitable gifts. Sometimes there's a beach house or vacation home, and the kids are planning on meeting there annually for Thanksgiving, and they come to find out that the parents have given the property to charity after their death. Kind of upsets expectations. You can do whatever you want with your property, and I encourage you to do so. But if there's something that is out of the ordinary, you might want to let the kids know that you're making a big charitable gift, something like that. And then finally, not paying attention to property tax consequences of transfers to real property. And this happens a lot. Parents will leave all of their assets in equal shares to their children, including their real property. And so let's use that the house situation. They have 3 kids. They leave it 1/3 each to the kids, and one of the children lives out of state. And they have no interest in ever moving to that property, or they don't want to be a landlord. They would prefer just to receive other assets, their cash equivalent of that real property. Well, if you don't deal with that appropriately in the estate plan, what happens is the 3 kids will receive a 1/3 share, and then the 2 that want to keep the house will buy the 3rd sibling out. Well, that 1/3 that they buy out is not a parent-child transfer. It is a transfer from sibling to sibling, and so it can cause a reassessment for property tax purposes, which otherwise could have been avoided had the estate plan distributed the house to the 2 kids that wanted it and given other assets to the sibling that didn't want it. So I'll end it there, and I'm happy to stick around for questions, and thank you all for being so patient and listening to me.
Well, thank you, Kevin. This was really amazing information. Several people posted how wonderful it was. And I say, great, thank you. That it's a lot of information, and we appreciate it. I want to, if you have any questions, please post them. Otherwise, I'm going to close. We have another message saying thank you very much. Thank you to everyone for attending, for your questions and participation. We want to extend a special vote of gratitude to our presenter, Kevin Gordon, for sharing his expertise. In addition, I'd like to thank the Mid-Career Alumni Network for suggesting this webinar and and John Phillips for helping me find Kevin. There are many ways to stay connected to the University of San Diego and the USD Alumni Association. We are on social media: Facebook, LinkedIn, Instagram, Twitter, Flickr, and YouTube. You can also connect through in-person social and networking activities. Alumni Honors is coming up this Saturday, April 25th. Josh Johnson and Jim Parsons are just two of the alumni honorees. Also, next Saturday, we have a Tecolote Canyon Cleanup Day. It's part of our community service and dedication to community involvement. Also in Orange County, we have a Pageant of the Masters pre-show and party coming up on July 11th, and then our annual Wine Classics, the 6th annual, on July 19th. No matter where you are, you're a Torero for life. Thank you again, and have a fantastic day. Bye-bye.